जो fact है, and
that offer of filing something you're not availing, you want to conclude, it's up to you.
Sir, there's just one point that I would ask that your Lordship hear me on. It'll take 2 minutes, sir. It'll take 2 minutes. If your Lordship just sees the order, the report of the SJC, I page
8. Page 39.
Ji, sir. Your Lordship sees that the first note is sent by the Secretary of the SJC.
Have you seen that already, Ji?
He is the complainant. Number 2 में अगर आप देखें, sir, the Chairman of the Council passes an order that the Chief Justice of the Islamabad High Court may comment upon veracity of allegations.
Ji, Mr. Khan has already referred to it. Ji,
sir. इसमें, sir, the Chairman of the SJC has directly started the inquiry
without assigning the matter to SJC.
ये अगर आप procedure भी देखें, rules 4 to 9. And of course, 209 ka 5 and 6, Article 209 ka 5 and 6, the SJC chairman has no role to play in terms of starting the inquiry. The inquiry has to be started by the Supreme Judicial Council. What is calling for a report from the Chief Justice of the Islamabad High Court and for evidence from Mr. Shukat Siddique, that itself was the inquiry. That is an act fully without jurisdiction, and the entire superstructure based on that falls, sir.
Anything else?
My lord, I'll file my written note, sir.
Okay. Anybody else wants to say anything? We'll wrap it up.
एक चीज मैं जनाब की तवज्जो दिलाना चाहूँगा, particularly his lordship's answer, very specific in this judgment of 2018. Page 569, what are the minimum standards of due process under Article 209? वो चंद लाइनें मैंने पढ़ के सुनानी है आपकी.
Where from? ये
PLD 2018 Supreme Court 538.
अच्छा आप ही का केस जी.
538.
रेलेवेंट बताएं. पेज बताएं. Relevant page.
Relevant at what page do you want to read from?
569.
569.
आपके सामने 569.
जी.
अब 69 आपके सामने है. जी सर. सेकंड लाइन से पढ़ना चाहूँ. There is no serious dispute.
Mike, Mike.
There is no serious dispute between the council appearing before us in this behalf, as none of them did or could have confessed that the procedure to be adopted by SJC can be unfair or unjust. This is obviously essential in order to ensure security of tenure of the judge, which is, as already stated above, is the primary purpose of Article 209 of the Constitution. The controversy perhaps pertains to the standards of due process which need to be observed and whether the SJC procedure of inquiry 2005, more particularly paragraph 13 thereof, meets such standards. There also appears to be consensus amongst the learned counsel, learned Attorney General for Pakistan and learned amicus curiae that except for the disputed paragraph 13 of the SJC procedure of inquiry 2005 and the remaining procedures compliant with the universally accepted principles of due process, including as reflected in our Constitution and the various pronouncements of this court. Now this is very important. The judge whose conduct or capacity is the subject matter of proceedings under Article 209 of the Constitution is issued a notice informing of the allegation against him. He is afforded a right of hearing. The findings are based on evidence. So this is most important. Based on evidence which are recorded in his presence. He is also afforded the right to cross-examine the witnesses and produce evidence in his defense. He has right to be represented by counsel of his own choice. These are the basic elements of due process given by this honorable court that SJC has to follow. So there cannot be any finding given by without evidence. And that evidence should be recorded in his presence with an opportunity to cross-examine.
Mr. Hamid Khan,
None of that has been
Mr.
done in
Hamid
this
Khan,
case. So therefore, mere
Mr.
show
Hamid-
cause notice means is neither here.
Mr. Hamid Khan, Article 10A has been incorporated in the Constitution, but the principles enunciated in Article 10A have been applied even prior to the incorporation of Article 10A. But now Article 10A is very much part of the Constitution. It has raised it to the level of a fundamental right.
Right, sir.
Due process and fair trial.
That's right.
Now, I'm speaking for myself. The point, I mean, even if you have to remove a Naib Qasid, there is a whole procedure. I mean, that is an employee of the government, not a constitutional office holder. And if surely the requirement should be higher, not lower, than for removing a Naib Qasid. I mean, I would imagine it should be. And if it, then otherwise, what's the worth of a constitutional office if it's not protected at all? So we have to see the Constitution as a whole. We cannot disregard fundamental rights. We cannot disregard the fact of the absence of an inquiry. If in the absence of an inquiry, someone is exonerated is one thing. But if in the absence of an inquiry, a person cannot be punished. I mean, I think these are the things which are quite clear and obvious. Now, the problem which is at least agitating my mind, and I want you to submit if you all can do so, is where does the Supreme Court draw its line as the Supreme Court of Pakistan not to encroach upon the domain of the Supreme Judicial Council. The Supreme Judicial Council may do some sort of inquiry. That's not the case before us, whether it was sufficient or insufficient. Here there is no inquiry.
No inquiry.
Unless the speech is in itself so offensive that it merits immediate removal. That's one aspect. The other is, if we read the show cause notice, is very much premised on institutions' integrity and institutions being maligned. So everything flows from it. You cannot disregard the content of the speech. Now, the content of the speech, there can be two things. It could have been misunderstood. That's not the case here. The question is it what the judge is saying correct or what the judge is saying not correct? You are saying it's correct, they are saying it's not correct. We wanted to hear their point of view. Yes, I did say this, I did meet him, but for a different purpose, whatever. That's not the case. No meeting. I never spoke to you, I never said anything. Now, we can't throw a coin in the air and decide who's right. Nor can we, which brings for you opened the door of 184(3). It's not a civil petition for leave to appear or a civil appeal, where our jurisdiction is wide and we can do whatever we want to. Now, my understanding of 184(3) is you have two hurdles you have to overcome. Matter of public importance. If you start asserting individual rights, which Mr. Salahuddin was trying to explain to the point that he's removing himself from the domain of 184(3), otherwise it may be a very good case. So if you come before us under 184(3), then it has to be a matter of public importance. And your rights, you have to link with the fact that removal, if it becomes so easy to remove a judge, then independence of judiciary as a whole is under threat.
Yes.
That's I accept. But if you only say, my removal is wrong, maybe you won't meet the test of 184(3). The next part is for seeking the enforcement of a fundamental right. Now, which is the fundamental right? Article 10A, maybe some other article as well, 25, I don't know, whatever you say. But so that's the thing. Where does the public, once we bring in public interest, public also has a right to know the truth. I mean, it shouldn't be perceived that we protect our own when they don't deserve protection. You know, that's very important, because this is really in the public domain. So, okay, fine, theek hai. So the public will say, but did he say it or not? Was it true or not? That's the question I was asking Mr. Salahuddin, and he was not coming up with that because he's actually taking his petition out of the domain of Article 184.3. Maybe it's all very new because these questions have just arisen during the course of the hearing. So we've given him time, and we'll also, and the last point is, where do we go from here? One is remand. Can we do it or not? He's saying once you retire, it's over. The learned Attorney General has referred to some other case and says, till that case is not decided, you should not decide this, or words to this effect. So if you can submit a note on these legal points, we'll reserve it. After, if we require to reconvene again, we will reconvene again. But otherwise, consider this, I mean, if my colleagues agree, for reserving the judgment subject to, we may want to reconvene after the notes come, or we may have more questions. I don't know. So is this clear? I mean, Khwaja Sahab, you agree with this course of action, or you can also submit us a note, because not necessarily, you said you're not invested in the outcome, you're more interested as counsel. Now we're calling upon you, senior counsel. If you can assist this court. The same applies to Mr. Wasim Sajjad Sahab. He's also very senior counsel. So he also said, I need time to absorb the matter.
With your Lordship permission, I'll submit a written note on legal issues. That
you may. Yes, please leave the facts aside.
Yes, that is
completely out.
We're not going into
at all. Don't mention anyone. No. Just on these issues. If you can, if you want to, you may. We are not directing you to, because you are not a party. Yes. But we felt that things were said behind your back, so you had the right of audience, which we've given you. So, which Hamid Khan Sahab also agreed. आपने पोस्ट तो नहीं किया था ना इनका नोटिस? इनको इशू करना हमने नोटिस आपने पोस्ट तो नहीं की थी ना? ठीक. तो कितना वक्त आप लोगों को चाहिए होगा to come up with some sort, because this is actually not only this case, every case creates precedent, but in these matters, the precedents are very rare. I mean, you know, like very few come, and this point is a novel point, and you said this, it's never happened that no inquiry has been conducted. Now we want to just see whether, I'm not doubting your statement, but Mr. Salahuddin and Mr. Khaja Haris Saab may tell us no, there are other cases where also inquiry were not held. We would want to know what is the world practice, whether it can be done without an inquiry of the nature that you're setting. We want to know about freedom of expression, of what judges can and cannot say. Because one is, I mean, even Khwaja Sahab was not very confident on which particular misconduct it is. I mean, publicity, I mean, so that allegation was not leveled. First allegation should have been leveled, you were seeking publicity. So anything else you want to say, please do so. Otherwise, this will be, we'll consider it reserved. ठीक है, लिख लें आज कोई है लिखने वाला ऑर्डर? आप इसमें लिखें.
2 weeks time.
Sir, I need only 1 week to have a comprehensive note on that.
देखिए आप आजकल जरा बहुत सारे केसेस आ रहे हैं, and all of them require a lot of thinking and detailing. So we'll certainly give you more than a week. I mean, it's not that. इसमें लिखिए, we've heard the notices were issued to